Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 23rd, and we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 bills on the docket. We're going to start off with, is Delegate Grammer here? No. All right. Well, then we have Delegate Attar is here. So we're going to start off with House Bill 159. Delegate Attar, welcome.
Vice Chair and members, for the record, I'm Delegate Zalia Attar, testifying in support of House Bill 159, Criminal Procedure Warrantless Arrests for Straw Purchases. Ending gun violence and removing illegal guns from the streets is all of our priorities. And I can say that with confidence. Currently, in the state of Maryland, it is a misdemeanor to conduct a straw purchase. Therefore, an officer cannot make an arrest for someone who is involved in a straw purchase without a warrant. The chances of straw purchases occurring in an officer's presence are very slim, and the fiscal notes there have been only 4 in the entire year of 2022. Now, while working as a prosecutor, I've been doing that for 8 years now, I've personally seen straw purchases occurring more than that. But because it's a misdemeanor and because the officers need warrants, many times the individuals selling the guns disappear, and it's very hard for them to go ahead and make these arrests. I therefore filed a bill last year, was similar to this, but it made straw purchases a felony instead of a misdemeanor. The House committee last year amended it to instead put it in the category of warrantless arrests. And the reason for that was because they believed they didn't want to make more felonies, which I agree with completely. I understand why we did that. This has a very similar end result. So with that, I ask for a favorable report, and I'll be happy to take any questions. Thank you.
Excellent. Thank you very much, Delegate. We're going to wait till the end of the panel, and then we'll take questions.
Perfect.
So, and then Senator Carter has a question for Delegate Attar. You want to do you have a
I just want to welcome you and acknowledge that this is Delegate Attar from the 41st District. Happy to have you here. Don't love your bill. And if I can ask a question now or later. So you brought the bill last year. We had some difficulty with it, not just me, in discussions, because there's some consternation about adding any additional warrantless arrest to the litany of things that police can do, because of the fact that warrantless arrests are very prone and subject to abuse. And then my consternation is that the gun, if the police already are going to arrest the person with the gun, and that's the dangerous part of this. And so I don't know that I believe there is a need to allow for a warrantless arrest, but all that being said, the bill calls for the potential warrantless arrest of a participant. And I also had concern about that. And so if you could answer, because I think that broad term could be a purchaser, a seller, a middleman, or even an onlooker who may be just in the area. And like, Mr. Giordano comes up and says, hey, do you know where I can get, a fire piece? And I'm standing there and I kind of nod my head saying, knowing that, over there, Delegate Attar has got one. And then that ostensibly could include me as a participant. And I think it goes too far. And that's the concern in terms of the warrantless arrest part.
So, Senator, I appreciate that. You did bring that concern to my attention. And right now, participant is not defined. I am not opposed to it being defined as the person who's selling the gun illegally and the person who's purchasing it illegally. What I can say is currently under the law, it is a warrantless. The officer can still arrest the person who purchased the gun because that is listed under warrantless arrest. So really, this is going after the person who is selling the gun illegally. And if the Senate committee decides to amend it to make it that participant is defined, I'm not opposed to that part of it. But I appreciate that. Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Erin Murphy. I'm the Director of Government Affairs for the Baltimore City Police Department. I'm actually testified on behalf of this bill on my second day in front of the House. We all know that straw purchases are a huge problem. They're actually the most common method of gun trafficking. There's more than 30,000 attempted straw purchases each year. That comes from the Giffords Law Center. I understand the opposition testimony that's been submitted, and the major complaint is, as we stated, that it's the warrantless arrest. I will point out that there are already misdemeanor warrantless arrests for domestic violence, for violations of protective orders, for stalking. It makes sense in this case. Straw purchases are likely not going to be made in front of an officer's presence. As we all know, gun violence is out of control in the state and in Baltimore City. Just last night, shortly after midnight, 6 individuals between the ages of 15 to 24 were shot in one incident in Western District. So to be brief, BPD supports any effort to reduce the amount of guns on our streets, and we are testifying in support of House Bill 159. And to your point, Senator Carter, if amendments do have to be made to understand participants, as a prior criminal defense lawyer for 20 years, I understand the concern. But I do think that this bill is important and necessary and can help us get guns off the streets. Thank you. I can serve here.
Good afternoon, Chairman Smith, Vice Chair Walter, and members of the committee, especially my senator from the great city of Baltimore, Senator Carter. I'm going to be very brief. My name is Hassan Giordano. I'm here as the Director of Government Relations on behalf of State's Attorney Ivan Bates and the Office of the State's Attorney for Baltimore City. We asked a favorable vote on HB 159. You have my written testimony, so I'm not going to reiterate what you can read, you've already read or may read. But as I'm sure you're quite aware by now, my boss, the state's attorney for the great city of Baltimore, Ivan Bates, is very laser focused on guns. And this is a major issue in Baltimore City and of course across the great state of Maryland. This is an issue that came across our desk and we're strongly in favor of Delegate Attar's bill. Senator, we hear the concerns of that. And of course, any amendments to that would be open from our standpoint. But these straw purchases, the ghost guns, the guns that I'm sure you've heard just from the state's attorney just the other day in regards to illegal guns on the streets of Baltimore is way out of control. Our office is vehemently in support of this piece of legislation. And we will answer any questions that you may have moving forward. Thank you so much for your time today and wish you the best.
Excellent. Thank you very much. All right. Questions from the committee, Senator Carter.
Thanks so much, Mr. Chair. My question is, if you can figure this out or find me the data, it'd be helpful to me. Either Ms. Murphy or Mr. Giordano from the Baltimore Police perspective or the state's attorney. We have a section in our code, public safety code, that deals with trafficking. And I was shocked to find it's an alleged trafficking from outside of the state into the state with the intent to, sell illegally. And if you can believe that, that's a misdemeanor. It's section 51-40. And my question is, if you may not have it with you today, because it's something you probably have to research. I don't really recall seeing that being charged very often. And I'm wondering if you can get me any data on the number of arrests and or prosecutions or charges under 5-140. So a dealer or other person may not transport a regulated firearm into the state for the purpose of unlawfully selling or trafficking the firearm. And believe it or not, the penalty is a misdemeanor. It has a serious potential penalty of 10 years, not exceeding 10 years.
Correct. I believe that it may be the state's attorney's office that has that data, but I can tell you that, Senator, when I was chief counsel over at the state's attorney's office, we did not see that charge often. Sorry. No worries. I should have thought about that. As I was saying, we can look into whether or not BPD has that data. I believe the state's attorney's office might. I also think that oftentimes you didn't see that charge because for quite some time, a lot of the trafficking was handled by the feds, and that happened often. There was also a trafficking task force at one point that was charging a lot of the HIDA task force were doing those. So I don't know that BPD has that data, but I will check for you. And if we have it, I will provide it. Thanks.
Any further questions for this panel? All right, seeing no questions, thank you so much for being here, delegate. Thank you, everyone. We'll now move to the opposition. And it looks like Davon Love is signed up. Is Davon here? All right, if Davon shows up, we'll have the opportunity to hear from him. Otherwise, that completes the hearing for House Bill 159. We will then, because I have a bill coming over to the House in rules, we'll move to Delegate Healy and Holmes with House Bill 462.
Thank you very much, Mr. Chairman. Members of the committee, good to see you all. House Bill 462 is about, it parallels the condo and HOA dispute resolution law that we all passed last year. This, as you probably know, the co-ops are common ownership communities, but they are in a different section of the Maryland Code and require separate bills. So this bill actually is supported by the Community Association Institute, and they have provided written testimony, certainly with most of the details that you would want to know about. Basically, what it does is it provides an alleged violator an opportunity for a hearing before the governing body upon request, but not requiring a hearing for each alleged violation of the community standards in circumstances where the alleged violator does not want and will not attend the hearing, so that they don't have hearings scheduled and nobody shows up and it's a waste of everybody's time. And that's all this does. It was passed unanimously in ENT and unanimously in the House of Delegates. So I hope that you can support it this year. I'd be happy to answer any questions.
All right, thank you, Delegate. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
All right, with that, that'll end the hearing for House Bill 462. Did we get to Delegate Grammer yet? Not. So you were first up on the list, House Bill 137, Delegate Grammer.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 137. House Bill 137 provides limited protection for teachers or staff members of a school for personal injury or property damage resulting from intervention in a student altercation or other student disturbance on a limited basis. Many jurisdictions have problems with the retention of teachers. I know Baltimore County does. If you speak with teachers, they express frustrations with concerns in the classroom. Teachers often report that they feel pinched by expectations of the school system while feeling unequipped to handle the issues that they encounter. Frequently, this disconnect drives teachers or staff members from work in education. And indeed, while county boards of education must provide legal counsel to a teacher for an intervening individual, there are no actual protections for a teacher who acts in good faith. So what this bill does is it offers narrow protections for teachers or staff who act to protect the student who is in danger or acts to de-escalate a violent situation, as long as they act in a prudent manner and as long as the actions taken do not constitute grossly negligent, willful, wanton, or intentionally tortious conduct. I feel that with this simple change, we can provide significant protections for good actors who act in defense of their students and take personal risk to de-escalate violent situations. This bill does include the amendment offered by the Association for Justice, which was offered in 2020, and this bill is in the same posture as it was when we last considered it. Thanks to those who have submitted written or oral support. And with that, I'd be happy to take questions and ask for a favorable on House Bill 137.
All right, thank you, Delegate Grammer.
Thanks so much.
Questions from Committee, no, all right, no questions. He was gone anyway. All right, no worries. House Bill 137, that concludes the testimony for that. We'll now move on to is Delegate Taylor with
Yeah.
House Bill 425. Welcome, how are you?
I'm great, thank you. Good afternoon, Mr. Chair, Vice Chair. For the record, I'm Delegate Kim Taylor, representing Prince George's County's District 23. I'm asking for support for House Bill 425, which is a bill that tightens up the language in Maryland's code that deals with land installment contracts. In short, a land installment contract is like a mortgage, but instead of using a lender, a seller finances the buyer. The buyer takes over the property management, repairs, makes payments, and makes payments to the seller until they reach the agreed upon purchase price. Clearly, there are benefits to both parties. However, historically, these contracts have been associated with predatory practices and exploit vulnerable and unsophisticated buyers. This bill passed the House favorably with no opposition. And we did include the amendment offered by the Office of Attorney General, which puts language back into the bill that protects buyers from overpaying for flipped properties. So I can go into more detail, be happy to answer questions at this point.
All right, thank you, Delegate Taylor. Questions from the committee? Seeing none, I'll just say, did you celebrate a wedding anniversary recently?
I
30
celebrated
31
31
years?
years
31
yesterday.
years, there you go.
Yes, thank you very much.
Congratulations.
Thank you.
There you
Appreciate
go. All right, but that'll end the hearing for House Bill 425. Thank you, Delegate Taylor. And now we'll move on to Delegate Holmes with House Bill 534. Welcome back.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I see some new faces here, Mr. Chair. And for all of you new faces here, all of you have a book on your desk. And as is my usual annual tradition, I give each one of you a new one every year, relevant to the rules, regulations, et cetera, for HOAs, condos, et cetera. What you have before you today is HB 534. It does three things. And I'll have to admit, I did not listen correctly to my grandfather when I was a little boy, who told me, boy, you gotta be more specific with your specificity. The first part of the bill, the first thing the bill does, it requires a deposit of reserve study funds. All of you who were here previously know that I had several bills for reserve studies and reserve study funding. However, when those bills got passed for reserve studies, I was not specific with my specificity. I did not say you had to deposit the money. So now I'm being very specific. The first part of the bill says you must deposit the money based upon the reserve study account. The second part of the second thing that the bill does is I received some concerns that the initial reserve study, I had a time limit of 3 years to fund the reserve study. I now have made that 5 years. And the last thing that the bill does is that it says that the common ownership communities must now have an annual review of their reserve funding, just to make sure that they're keeping track. And with that, Mr. Chair, I will entertain questions.
So, thank you very much, Delegate Holmes. We have a question for Senator McKay.
Yes, Delegate, good to see you, sir.
Good to see you as well.
What was the vote on these bills?
I believe they were unanimous.
Even on the House floor?
I have to check. I don't know for sure. I'll have to
Well,
check.
I looked here and it says a Delegate Wyval. I was just wondering had he articulated to you why he was not in favor of it, or just did he bump his head?
Well, I think Delegate Wyval, quite frankly, had a finger malfunction.
It's par for the course.
He had a finger malfunction, and he and I had a discussion about that one evening over some refreshments.
Libations. Thank you. Thank you.
Yes, indeed.
All right. This reminds me, for all lawyers in the House, reminds me of the blue book, except it's green. Anyway. All right. It does look like the blue book, doesn't it? Anyway, all right. All right. All right. Seeing no further questions, that'll end the hearing for House Bill.
Thank you so much.
534. Thank you very much. All right. I see Delegate Lewis is here. Let's do House Bill 567. Welcome.
Thank you, Mr. Chair. Great to see you, Mr. Vice Chair, esteemed members of JPR. I'm Delegate Robin Lewis here in support of House Bill 567. This is a bill that will help increase the pool of affordable housing units in the state of Maryland. And as I'm sure you all know, according to the Realtors Association, we have a shortage of about 120,000 housing units in the state of Maryland. This bill goes some small way to tackling that gap. Now, if you love real estate law, you'll probably love this bill. It gets in the weeds. Here's what it does. This bill removes a loophole that increases the expense for land trusts when they want to develop multifamily housing units. This is something that I was blissfully ignorant of in my previous life, but I'm now super passionate about making it easier for land trusts to purchase and develop property and create the pool of homes for hardworking Marylanders. You'll see my testimony. This bill passed the House of Delegates unanimously. It's a simple technical fix to the Affordable Housing Land Trust Act. It just makes it more affordable for land trusts to purchase and develop multifamily homes. I'll also remind the committee that in the state of Maryland, we were in the forefront of creating affordable housing land trusts. The state passed its first land trust, or the foundational land trust bill, before some of you were born, back in the year 2010. And since then, land trust organizations have popped up in nearly every county, from Kent and Caroline counties to Frederick, Anne Arundel, and Howard. There are opportunities all around our state to create affordable home ownership. With that, I'll ask your favorable report on House Bill 567. Thank you.
Mr. Chair, thank you so much, Delegate Lewis. I don't think there's a Senate crossfile. Is that correct?
No, ma'am, there is not a Senate crossfile.
So I'm taking a look at it, and just generally, I feel like you mentioned we've been at the forefront, and that's what I was thinking. I feel like every time I turn around, there is a new either creation of a land trust, even in our city, or talk of it, but I don't feel that I see the results of that very often. So the way you describe the bill, this impediment could be helpful.
Absolutely. This is a perfect example. I know there are probably many around the state, but there's a perfect example from Baltimore City. The South Baltimore Land Trust, located in Cherry Hill, Curtis Bay, Westport area. They have the ability to access land thanks to some capital funding from the state, from us, but from other sources. They've got the land, and what they'd like to do is develop a multifamily unit there. When you do multifamily housing under a land trust, you have to rely on condominium law. When this land trust went to start developing a multifamily unit, they discovered that under current law, they would have to create two different condominium entities, go through a series of two separate and very expensive legal procedures that cost a lot of money. And as many of you in here know, attorneys are expensive, and there are extra fees involved with, the purchase and other aspects of the land acquisition. They basically have to double their expense to create multifamily. And we need multifamily housing. And so that's really how I learned about the need for this fix in state law through the South Baltimore Community Land Trust. This will fix their problem and unleash, I pray, more opportunity statewide. Thank you for the question.
I really don't want to belabor this, but so the bill is limited to, or the title, and it looks like the bill is limited to condominium.
The reason for that is a quirk in state law. It has to do with the terms we use when we describe multifamily housing developed under a land trust. So, and this is real estate law, and is Delegate Holmes still here? I'd love
It's okay. No, I was curious. So the same impediment does not exist outside of this one area, or it does?
Correct.
Okay.
So how in Maryland, we have inherited this very exotic leasehold legal structure. We have ground rents, and it's a leasehold estate is how some of these properties are defined, particularly in old places like Baltimore City. So when you buy a property, you've got to research in the title whether there's a ground rent that's due, and it just makes it more complicated. So the State Residential Condominium Act requires that if you're a land trust is building multifamily homes, they are subject to this ground lease system. So ground leases are the bugaboo of real estate law in Maryland. This helps fix it, at least for this. So I believe we'll start to see more housing emerge very soon if we get rid of some of the obstacles that are in our state law. And
Thank
I
you
hope
very
you'll
much.
support this. Thank you so much.
All right. Additional questions? All right, seeing none. Thank you very much, Delegate.
Thank you so
Always
much.
good to see you. All right, with that, that'll end the hearing for House Bill 567 and the House bills for the day. We'll now switch over to our two remaining Senate bills. Senator James with Senate Bill 899 and Senate Bill 9071. So which one would you like to take first, Senator?
It shouldn't be. I don't have it. I was trying to see. I guess we'll do the real estate one first.
Okay,
Chairman, if
so
that's all right.
Senate, just for the record, Senate Bill 971.
Yes, thank you, Mr. Chairman, members of the committee. For the record, Mary Delaney James, Senator from Harford County, District 34. The main purpose of Senate Bill 971 is to require some collaboration between the clerks of the courts and state and local officials regarding land recordization. And then insert some certainty and predictability in the public taxes and fees and assessments that have to be paid before a transaction can be recorded as well. And I think I have Phil O'Connell from the real estate section of the Maryland State Bar here, and I've been working with them closely, and there is a fair amount of collaboration on this bill. Just a little bit of background. You know, the clerks, as you all probably know, manage the land recordization system, our state system, and that kind of makes sense because deeds, I'm going to use deeds, lots of land records have to be recorded, but we'll just use deeds. You know, they have to be filed where the land is situated. But over the years, a lot of local requirements have built up and in that the counties and municipalities have gotten involved. And in particular, in addition to the real estate taxes, that makes sense. Everybody knows you have to pay them. Counties and towns have been sort of loading up the process with special assessments, special district taxes, personal property taxes, hotel taxes, water and sewer taxes, town taxes, and so on. So, and this is kind of a fractured system, and it's kind of grown up. It's not only fractured across the state, it's kind of fractured within the counties that, you know, I can go into more detail about. And that fractures has run headlong into another issue, which is really about us, you know, the state's moving toward being more electronic in terms of the services and platforms we provide to constituents and businesses in the state. So in 2015, we did in fact pass the Electronic Records Act, which is great. And it does, you know, work to some extent, but it really only so far works with very simple recording packages. So the vast majority of even complex residential as well as commercial transactions, they have to still be done in person. Now, going back to the tangential fee, all those fees I just mentioned, the practical effect of these two issues is that you have to go not only to visit the clerk of the court, but you have to you could travel all around the county and go to a city hall here, a local administrator there, a treasurer in this place, director of finance over there. And these visits can take a couple of hours, and sometimes just because of, I'm sure it's just staffing issues or whatever in small offices, they tell you to leave the documents, just leave them, and then you got to come back the next day. So this process that could be very simple or at least more streamlined gets really protracted. And just to add just another little caveat, some local jurisdictions even have special forms into what we have a Maryland standardized intake sheet, and that is for, you know, to promote uniformity, and yet local jurisdictions are developing special forms. And then just, you know, I kind of mentioned the unevenness of how local governments and maybe municipalities have been rolling out or using online platforms. The other issue is that
some of these fees and taxes and assessments, they're not even online. So even if you're, a savvy person in the settlement real estate business, and you can do your due diligence and you can go and look every place you can possibly think of for where fees and charges might have to be, what you'd have to pay. They're actually, some of them are just not posted. So what that means is that these very same local governments or towns can literally block the closing, until the fees are paid, which is a pretty sharp practice. But even sort of worse, it puts the settlement industry, it either turns into a sort of de facto collection agency, or they get holding the bag and take a loss on the hidden charges. So this bill, let me just say that I think everybody recognizes there ought to be an overhaul. I think there's some progress going to be made with that. So this bill just is two small changes. One is to change the word may to shall in 3-703. And that's to let the clerks of the court sort of take the lead to work with the other stakeholders and entity, government, state and local, to try to streamline this process, try to make it work a little bit better, make sure all the fees and assessments and documents that have to be taken care of before you can close the deal. Let's make sure they're working together. So that's the may to the shall. And the other is Baltimore City has a really smart, I think, language in it that talks about, there's something called a certificate that you file with these deals. And it shows all the charges and fees that I just discussed, and you're supposed to be able to rely on them. But Baltimore City requires that they be accurate, and because they require it, you can rely on it. So our bill, this bill, takes that language and says, let's put that in the state code. So I'd like to also just sort of in closing say to you that the clerks of the court sent me an email, which I gave you, which they support this. There isn't any opposition that I know of. And I think it's a good first start. So I hope you'll favorably consider it. And like I said, I have people here who can answer more questions.
Excellent. Thank you very much, Senator. Questions from the committee? All right. Excellent. With that on the hearing for Senate Bill 971, we'll now move on to Senate Bill 899 with Senator James. You're up.
Thank you again. Thank you, Mr. Chairman. Again, Mary Delaney James, State Senator from Hartford County, District 34. Over the last 15 years or so, there are three very alarming trends. First, the victims of child pornography are getting younger, much younger, prepubescent, toddlers, infants. Second, because of how young these victims are, the hideous acts done against them are all violent. They're all violent. And really, I worked with the state's attorneys on this, and they gave me some examples. It would be beyond a normal person's comprehension if it were not described to you. The third is there are just advances in technology, computer, internet data storage, so that perpetrators now have hundreds, but oftentimes thousands of these images or videos. So this bill is just going to do three things as a start, and it is a start. I want to work with people to do more in this area. But the first thing is to allow the combination of 100 or more images in a single count in the initial part of the pleading. I just told you, usually there are now hundreds and thousands of these images. So pleading it one count, describing one image, you could end up with a pleading with 100 counts, 1,000 counts, 2,000 counts, and it just becomes very unwieldy. Second, it is to increase the penalties for child pornography for victims under the age of 5. And then finally, it increases the penalty for people who have images over 100. There is this constant escalation between these negative trends. Demand is fueling the supply. The supply is desensitizing the perpetrators. The perpetrators see things and think they are normal, so they demand even more depraved, vicious, violent acts to be portrayed in images. let me just give you a little more background because I'm the only one speaking and I don't have a panel because the panels would have covered all this. From 2000 to 2011 alone, just at the federal level, images went from being 5 million that they had access to 22 million. But just think about that. That's the production level increases that are being churned out. 85% of these people that are using these images are men. And really, so you get to the real heart of this, a vast majority of them are hands-on commit hands-on offenses as well as looking at these images. At the same time, the federal government has a report out in 2019 that says, look, just to confirm what I told you, the median number of images is over 4,000, but many are over 100,000 or 1 million. And then I did research around the states, and you'll see in my testimony, 20,000, 50,000, 100,000, very typical. The other thing that the federal sentencing of child pornography report said in 2019, 52% of the offenses are images of infants and toddlers. And nearly every offense is a very young prepubescent child. So this is just incredibly disturbing and it's an incredible trend. And so then I looked around the country and I saw that state after state was finding the same thing. I took the time to give you citations so you could see some of what I found out in my own research. And so at the federal level, already you're allowed for enhancements of penalties for the age of the victim, the brutality of the image, and the number of images. And at the state level, and I gave you some information, the same thing is happening. So this bill is going after that same thing, enhancing because of the age, enhancing because of the amount of the images, right? What I want to tell you, the last thing I want to say to you is an expert in this area, I think, captured it. We don't say the words child pornography because the accurate description is images of sexual assault on a child. So I think this bill is a good first step. Now, I'm aware that MCASA actually supports the bill, but wants us to go further. I would be happy to go further, but what I don't want to do is jeopardize the bill in any way that it would not at least succeed to get through the Senate and the House, hopefully this year. So I don't want to do something that would jeopardize it. And the bill is very consistent with what the federal government's doing and what many states are starting to do. So with that, I hope for a favorable consideration. Be glad to answer any questions.
All right, thanks, Senator James. Thank you for bringing the bill forward, and I couldn't agree with you more. This is the first time I'm not familiar with this. It's the first time we've seen this bill. So
Yes.
I just had a quick question for the videos. I mean, I think it's on page 2. Just why? So each video, electronic video, film, videotape, or similar depiction shall be considered to contain 20 representations, because it seems to me that each frame could be an image. And there are thousands of frames in a video. And if you had a video that was 2 minutes long by 3 hour long video, their counting is the same.
Right. I wish the
just want to know where it came from
here, but they're telling me this is about pleading it. This is about the fact that, yes, you could stop each frame. And again, the way you would have to do this count by count is just too large. So this gives them an ease. And if you look at the other states, because I'm not an expert in how you plead the cases, if you look at the other states, this is typical language between batching the still images and then accommodating video images by giving them this 20. You could pick a different number, but that's the idea of making it easier to plead the cases.
Excellent. No, just curious as to what the genesis of that was.
Thing.
Senator West.
I think this bill is great. I think I tend to agree with the advocates that we should go further. I don't want to jeopardize, I agree with you. I don't want to jeopardize the passage of this bill, but it's hard to imagine why we would consider these sorts of atrocious offenses as just misdemeanors. It seems to me at the higher levels, they ought to be considered felonies.
And I think in the bill, I believe, let me find it. I think we did. Hold on. you know, you might be right that they did not choose to even have a subsequent offense become a felony.
No.
Right. Look, that's.
If we were to adopt that sort of language, the substantive offense becomes a felony, that wouldn't upset you, would it?
No. No, I'm telling you, I will tell you, I deferred to them, these people that do this day in and day out. They wanted to come in sort of a modest proposal. Me, I agree with you. I would do more, especially because we are making all these strides in dealing with children that are being trafficked and children that are being abused. We're really children that, you know, we're giving the opportunity to go backwards in time. We're coming to this really consciousness, right, about all of this. So this bill was modest. They thought it would do better if it started smaller. And I don't want to jeopardize it. And I don't have as much experience as the state's attorneys do in terms of what they think can pass, but I would defer to the wisdom of this committee and what you think the House would do, you know, to try to get this bill through.
Is there a House crosswalk for this?
I don't think so.
Okay.
And I'll honestly, Senator West, they came to me after talking to the chairman, the vice chairman, and only when I really vetted this. So it's late, and I think they were trying to find a senator to start it with. So I wish there were a crossfire.
Thank you so much for your answers.
Sure.
All right, additional questions from the committee? Excellent. Thank you very much, Senator.
Thank you.
All right, with that. It is a subsequent, yeah, it's a felony. All right, so with that, that'll conclude the hearing for Senate Bill 899 and our hearings for the day. We are going to reconvene in literally 5 minutes, so don't go anywhere for a voting session. And we are not voting tomorrow. So if we get through this, we can get through it quickly. Yeah, there you go. You're free to work on your other affairs. All right.